Hello everyone. In this lecture series, I am going to start land laws unit wise. In land laws, these are the acts which are covered. So the first is the AP Enams and Conversion into Right to Waris Act, AP Tenancy Act, AP Buildings Lease Rent and Eviction Control Act, Land Acquisition Act, Land Requisition Act, AP Land Reform Ceilings on Agricultural Holdings, the Urban Land Act, and the AP Land Grabbing Act. So these are the acts which are covered under the land laws. Before going into the first unit, I hope that you all have completed the Transfer of Property Act, so it could be easy to understand the concepts in land laws. So let us start with the first unit. The first concept is ownership of land. So let us understand first the meaning of ownership. I'll explain this concept in two parts, that is the ownership and land. So ownership means it is the exclusive right, control over property. Ownership is the exclusive rights and control over a property. Property here includes all the immovable, movable, and intellectual property. Immovable property includes a land, building, etc. And movable properties includes a pen, bottle, book, etc. And intellectual properties are of three types, that is patent, trademark, and copyrights. So these all comes under the definition of property. So the rights and control over all these property is called as an ownership. Land ownership. So in this concept, we are learning only about ownership of land, that is immovable property. So land ownership is broadly determined by access to land title. So how can we determine the ownership of a land? By accessing the land title, a document that states such ownership. This document states about the ownership of a land. That means who is the owner of the land, what is the extent of the land, and all the details of land, the land, where the location of the land, etc. All these details are present in the land title. So having a clear land title protects the rights of the title holder against other claims made by anyone else in the property. So the title deed should be clear so that it could protect any other claims. That means from any other person, preventing any other person from claiming the land, stating that this land belongs to him. So, a clear land title is very essential. In India, land ownership is determined through various records such as registered sale deeds, property tax documents, and government survey records. The ownership of the land, we can also verify by knowing the sale deeds or property tax documents and government survey records. So these are the ways by which an ownership of a land could be known. The next point is the ownership of property can be gained through various ways such as purchase, gift, trading it for other property. These are the ways by which an ownership could be gained. Ownership of a property could be gained. That is through purchase, means buying it for some price, or gift. This means that if someone gifts the property to the other person, or trading it for other property, giving one property for some other. So these are the ways by which ownership of a land could be gained. And the next and last point is one can transfer or lose ownership of property by sale, gift, robbery, misplacing it, or through legal means such as eviction, foreclosure, seizure, or taking. So how can an ownership of a property could be lost is by these ways, that is sale. If someone sells his property to another, the ownership rights are also being transferred to that person, or through gift. In all these cases, the ownership of the property will be transferred from one person to other, or through legal means such as eviction, foreclosure, seizure, or taking. These are usually done by the government for some public purpose. So in these cases, the government can evict the people or foreclose the place, seize or directly take the property from the public. So in these cases also the ownership will be transferred. So these are the ways by which an ownership could be lost. The next concept is incidence of ownership. Incidence means the rights or benefits arising out of ownership. Right to possess, right to use and enjoy, right to dispose of, right to exclude others. So by gaining or taking an ownership of a property, a person can have the right to possession, right to use it and enjoy it, right to dispose of. That means he can sell it, or he can gift it to someone, or he can even mortgage it. So these are the ways of disposing of a property. And exclude others. That means a person can, or the owner of the property can exclude anyone from entering into the property. So these are the rights and benefits of an ownership. The next is the kinds of ownership. First kind of ownership is the sole ownership and co-ownership. Sole ownership is when only one person has the whole and sole right in a property. This means that if a person purchases a property, the whole and sole rights on that property will be for that person alone, and no one else can claim any right whatsoever for the property in question. So this is about sole ownership. And when two or more individuals share ownership of a property or asset, they are co-owners. For example, there are three partners, partner 1, 2, 3, and they have purchased a property. So in this case, the property belongs to these three persons. The co-ownership is further divided into joint tenancy, tenancy in entirety, and tenancy in common. So joint tenancy means owners have equal shares and equal rights to the property. One owner dies, their share automatically transfers to the surviving owner. For example, A and B have purchased a property, and A and B have equal shares in this property. So if A dies, the share of A will also be transferred to B. That means now B will have the whole property. So this is called as joint tenancy. And tenancy in entirety. It is exclusively for married couples. This form ensures both parties have equal rights and equal shares. Here, A and B are married couple and they have jointly purchased this property. The property cannot be divided. And in tenancy in entirety, the entire property belongs to both of them and it cannot be divided. And if A or B, either of the party, want to sell this property, they cannot sell without the consent of the other. The consent of both the parties is must to sell this property. And the third form is tenancy in common. Owners have individual shares in the property which can be unequal. Each owner can pass on their share through will to their legal heirs. In this type of case, again, A and B have purchased a property, but here the shares of A and B are unequal. That is, it could be 30 and 70. So here, if one person dies, either A or B dies, they can transfer the property to their legal heir in form of will. So in this case, the property will be transferred to their legal heirs. So that is the difference between tenancy in common and joint tenancy. In joint tenancy, the property will be transferred to the surviving owner. But in this case, the owner can transfer his property to his legal heirs.
Next is trust and beneficial ownership. In trust and beneficial ownership, the property is owned by two or more persons. One is under the obligation of using it for the benefit of the other, and the other is for whose benefit the property is used. Let us say A have transferred his property to B in trust for the benefit of C, who is A's son of A. So here B cannot have any benefits of that property. He can only use the property, the benefits of arising out of the property for only C. So this type of ownership is called as trust ownership. Here B, the former is called as trustee. B is called as trustee. And for whose benefit, and the later is called as beneficiary. C is called beneficiary. The ownership that he holds is the beneficial ownership. C is holding a beneficial ownership and B is holding a trust ownership. The property is called as the trust property and the property in question is called as trust property. The trustee is only a nominal owner and has no right of enjoyment of trust property. B cannot enjoy the property. He can only use it for the benefit of C. This is usually done while transferring a property to unborn persons or persons incapable due to lunacy, infancy, or absence. That means here, if C is a minor or who is suffering with some disease who cannot manage the property. So here B is entrusted as a trustee by A. So all the profits and benefits arising out of this property is used for C. And the next type of ownership is legal ownership and equitable ownership. The ownership which has its origin in the rules of common law and are recognized by common law courts. The legal ownership is recognized by the common law courts. For example, A has purchased certain property from B for some consideration. So now A is having legal ownership over that property. A is having legal ownership of that property. The ownership which has its origin in the rules of equity and are recognized by equity courts. So, what is meant by equitable ownership is A has purchased a property, but A only paid the amount. He has purchased the property on the name of B. So, here B will be having equitable ownership, which means he may or may not have the right to enjoy the property because A has paid the amount. So, this is about legal ownership and equitable ownership. Next is the vested and contingent ownership. The ownership is vested when the owner's title is already perfect. It is absolute in nature. When the title of the owner is imperfect and it will become perfect on fulfillment of certain condition, it is conditional in nature. Let us understand this with an example. A is the husband and B is the wife. So A has written a will in which he stated that upon the death of A, the property will be transferred to B. And after B's death, the property will be transferred to C and then to D. So here A had died. Now the property will be transferred to B. B is having vested interest over that property. He is having vested and absolute interest over that property. When, when it comes to C, C has imperfect title because C can gain the ownership of the property only after the death of B. Until then, C is having imperfect title. So it will become perfect. The title of C will become perfect only on the death of B. So this type of ownership is called as contingent ownership, which is conditional in nature. What is the condition? That B should die. Only after the death of B, C can acquire the property. And the conditions can be condition precedent and condition subsequent. It is the condition by the fulfillment of which an incomplete title is completed. Here, C's title is incomplete. Only after the death of B, that is a condition precedent. What is the condition? That on the death of B, C can acquire the property. So, this condition is called as condition precedent. After the condition is completed, the title will become perfect. And condition subsequent means it is a condition by the fulfillment of which title already completed is extinguished. Let us take another example where A and B. A has written a will again stating that on the death of A, B will acquire the property. B will acquire the ownership of the property. So, but there is a condition subsequent. B will acquire the property. But if B remarries some other person, then the property will be transferred to C. So here the title is completed upon death of A, B will acquire the property. But if the condition is fulfilled, that is B remarries, the property will be transferred to C. That is, the right will be extinguished. That is called as condition subsequent. Next is absolute and limited ownership. In absolute ownership, all the rights in respect of the thing owned is vested in the owner. That is, if A purchases a building, the whole and sole rights is vested on A. So here A will be called as absolute owner. In limited ownership, limitations are imposed on the right of owner in respect of the property. So here A have leased the building to B to rent. So here B is a limited owner. He cannot have the absolute rights over the property. That means here A can sell it, lease it, or he can gift it. These all are the rights which are with only A because he is the absolute owner. But with B, he doesn't have any such rights because he's just a limited owner. He cannot sell it or lease it. He doesn't have all these rights. So, this is the difference between uh, an absolute owner and limited ownership. So, that's all for this class. I hope you all have understood the concept. Thank you.